Given this, I would like to share some judicial cases and our practical experiences and provide you with some useful references for writing or sending warning letters. Here is a catwalk for today's report. Firstly, we will discuss the usage of patent infringement warning letters. Secondly, we will cover important attention points before sending letters, including pre-measures that can be taken before sending. And then we will provide 3 case examples regarding patent infringement warning letter. The first 2 are classic Chinese judicial cases, and the third one is a case from one of our law firm's clients. Finally, we will give some suggestions for drafting effective warning letters. First thing first, let's talk about why you might want to use an infringement warning letter. It's a really common way for patentee to try and stop alleged infringers from continuing their manufacturing or selling activities. It provides a low-cost and efficient way to seize the alleged infringer's ongoing infringement. It can stop the infringer from manufacturing or selling infringing products. Plus, it can help you prepare for a potential lawsuit, such as extend statute of limitation. Speaking of which, the statute of limitation is a legal term refers to the time limit within which a patentee can file a lawsuit requesting protection of their rights at a people's court from the day they become aware or should have become aware that their rights were infringed. In simple terms, if the patentee does not file a lawsuit within this time limit, they lose the qualification to assert their rights in court. And there's 2 main ways a warning letter can extend the statute of limitations. First, a warning letter can interrupt the statute of limitations. When the patentee sends a warning letter to the infringer, it is an appearance of patentee to actively assert their rights, which can interrupt the statute of limitations, causing the limitations period to be recalculated. Secondly, a warning letter can constitute evidence of continued infringement. The occurrence time of an infringing act is from when the infringer begins infringing to when the infringing act ends. If the patentee can prove that the infringer continued their infringing acts after receiving the warning letter, the end time of the infringement will be extended accordingly, thus extending the statute of limitations period. Well, let's turn back. The third usage of the warning letter is it can even seek increased compensation. In China, by demonstrating that the defendant intentionally infringed the intellectual property rights, the patentees may ask for punitive damages. This allowed you to presume greater monetary relief for deliberate infringement. But hold on a second. Before you go sending out those letters, there are a few things that you should keep in mind. First, Chinese law does not require a warning letter to be sent prior to filing a patent infringement lawsuit. In China, the patentee can directly file a lawsuit and seek damage for infringement. In addition, it's important to remember that as a patent owner, you are gonna have a higher burden of proof in China when it comes to showing that infringement took place. So you wanna make sure you have all your ducks in a row before you start making any demands. Speaking of this, you may wonder, why does a patent owner have a higher burden of proof? The burden of proof borne by claimant principle established in Chinese civil law, that is, as a party who initiates and may claim the litigation, the plaintiff and needs to provide evidence to prove the facts claimed in its litigation request. If the plaintiff to prove its case, the court will dismiss the plaintiff's litigation request. Thus, it is crucial to have enough evidence to prove the infringement and seek legal evidence before proceeding with a warning letter. The key evidence in patent infringement litigation includes, first, evidence proving ownership of patent rights, such as patent certificate, patent evaluation report, certified copied, patent annual fee receipt. And second, evidence proving infringement, such as notarized purchase of infringing products, documentary evidence, or physical evidence. And the third, evidence proving damage, such as lost profits analysis or licensing fee calculations. Attention, evidence like patent license agreement, financial audit report, screenshots of sales volumes, slides, or promotional materials displayed by infringing sellers at trade shows. And I want to briefly introduce the patent evaluation report. The patent evaluation report is issued by the China Intellectual Property Association. It provides a professional evaluation of the patent's technical scope, potential economic value, validated, and infringement risks. Upon receiving the application, China Intellectual Property Association will review the patent and send the finished report within 2 months. The report will analyze the patent's claims, specification, priori art, and provide a comprehensive assessment. It serves as important evidence for patent owner to determine infringement and prepare for litigation. So can anybody guess, before sending a warning letter, which of the following 3 types of evidence do you think is most important to preserve? The answer is the crucial consideration before sending a warning letter is preventing the loss of evidence, especially by securing preliminary evidence of infringement. This is because web page content or products may change or be taken offline, potentially causing relevant evidence to be lost and affecting future rights protection or litigation. It not only provides a basis for issuing the warning letter, but also creates conditions for further action to protect rights and pursue legal liability. Therefore, web notarization and purchase notarization should be performed in advance to preserve the evidence of infringement. These measures can effectively save suspected infringing websites content or obtain suspected infringing products as legal evidence. In addition, if the patent owner intends to file a takedown request on an e-commerce platform, web notarization or purchase notarization would also be necessary. I give you a second. I think maybe somebody need to take photos. And finally, there are some legal risks associated with sending out a warning letter that you need to be aware of. For example, the alleged infringer who received those letters may file some lawsuit. For example, the alleged infringer who received those letters could turn around and file an unfair competition lawsuit against you, claiming that you have abused your patent rights. The case study we are going to discuss next involves unfair competition litigation. So we will hold off on explaining the details for now. And second, they could even file a patent invalidation procedure on the excuse that your patent right is unstable. Furthermore, the alleged infringer may also file a confirmation of non-infringement lawsuit. Let me explain what this is. The confirmation of non-infringement lawsuit refers to the alleged infringer's request to the court to confirm that its Intellectual Property Act does not constitute an infringement based on the consideration of its patents or products are legitimated in order to eliminate the actual threat of infringement or the suspicion of infringement. In other words, the alleged infringer take a proactive step to clear their name by filing a lawsuit. The purpose of filing a non-infringement lawsuit is usually the alleged infringer to remove a cloud of uncertainty over the alleged infringer business due to warning or threats of legal action by the patentee, prevent potential loss of goodwill, customer base, and the revenue stream. And it can gain leverage for settlement. A successful non-infringement ruling can effectively end the dispute with a full clearance to continue commercial activity. Failure to win a non-infringement lawsuit, however, typically means facing an increased risk of an infringement lawsuit by the patentee. Now, returning to our original discussion, how can we prevent the loss of evidence or minimize legal risks? Well, we recommend that our clients take following steps before sending any letters. For example, you should conduct a preliminary comparative infringement analysis and evaluate the stability of the patent. You will also need to analyze the potential risk of sending the warning letter and evidence collection. Vital evidence may be hidden or destroyed by the infringer after the warning letter has been sent. And it's always a good idea to initiate a preliminary investigation of the infringer. Seek out evidence presented by the infringer at industry conventions. For instance, exhibition, photographs, and slides from presentations given, along with any promotional publications for the violating product released. Finally, it is critical that judge the effect of sending the letter. If the distributors may take down after receiving our letters, it can be sent. For instance, a small-scale distributors who may more voluntarily to take down products. Who may more voluntarily to take down products, or else the letter could be skipped and litigation can be pursued directly. The fourth step is we recommend our clients to do before sending those letters. Moving on, for further, this is the basic framework of the warning letter. Typically, a patent infringement warning letter usually contains the following sections. First, recipient information. Clearly state the full name, address, contact details of the recipient. Second, infringed patent information. Specify the infringed patent number, patent name, authorized country, etc. The third, description of infringing acts. Describe the specific infringing products, activities, etc. of the recipient. Fourth, legal basis. Include relevant legal provisions showing the right to send such infringement warning letter. And then the demands and warnings. Formally demands the recipient cease all infringing activities of the patent by a certain date. For example, specified a deadline such as 10 working days upon receipt of letter. Next, consequences of continued infringement. State that without compliance will result in legal action, including recovery of profits and damage, etc. And attorney contact information. Provide contact details for response. And then law firm sealed. State the law firm's official seal and date. And finally, attachment. Attach evidence of infringement, such as photos of products, patent certificates, evaluation reports, etc. These photos mean the alleged infringing products. In summary, an effective patent infringement warning letter balances considered evidence, clarity on consequences, and an opening for discussion. The specific strategies implied should be tailored to the situation's unique circumstances in order to productively achieve the objective of protecting intellectual property rights. Moving on, for further discussion, I want to talk about two classic Chinese judicial cases that are worth mentioning. These sections will introduce the Shuanghuang versus Honda case and the Adam versus Mandarin case. We will compare and contrast key aspects of these two influential cases related to unfair competition litigation in China. This analysis will also include reflected commentary and a concise summary of the cases, essential details, and implication. The goal is to illuminate what exactly a patent warning letter should have in order to be as risk-averse as possible. Here is a briefing of Shuanghuang versus Honda unfair competition case. The patent litigation between Honda and Shuanghuang started in 2003 and lasted for 12 long years of back and forth until the Supreme Court's final judgment put an end to it in 2015. In short, the root of the case was that Honda argued that Shuanghuang had infringed, but Shuanghuang argued that it had not and that Honda had seriously affected its market. So it brought a separate unfair competition case. The result was that Shuanghuang was not infringed. Honda was ruled to compensate Shuanghuang for losses caused by Honda's improper warning letter. The figure shows one of Honda's design patent for a car exterior. And with the right picture depicting Honda's famous CR-V model, and the left picture showing a car made by Shuanghuang. And here is another case briefing. This is Allen versus Mandarin commercial defamation case. Mandarin and Allen are two companies focused on manufacturing medical devices. In 2011, after filing 23 lawsuits against Allen, Mandarin sent warning letters to several of Allen's distributors, claiming that Allen's blood pressure monitors, patent monitors, ultrasound diagnostic equipment infringe Mandarin's patents. Allen believes that Mandarin's withdrawal of 12 of those lawsuits proves that Mandarin lawsuits against Allen were malicious in nature. Allen also notes that 2011 was when Allen was going public, and Mandarin intentionally filed lawsuit at that time in order to defend Allen commercially. And the result is in Shuanghuang versus Honda unfair competition case. Honda believed that Shuanghuang had infringed its design patent rights and sent warning letters to more than 10 Shuanghuang dealers nationwide, resulting in serious damage to Shuanghuang's market. Ultimately, the court found that Shuanghuang's products were not infringing, and Honda was ordered to pay 60 million yuan in compensation to Shuanghuang. However, in Allen versus Mandarin case, the situation is totally different. The content of the warning letter was consistent with the facts, and the court determined that it constitutes a legitimate act of defending one's right and interest rather than commercial defamation by fabricating false facts. The court held that Mandarin's act of sending a lawyer's letter, a warning letter, was justified, given that the warning letter was an expression of its unilateral view, and the value of which was the use of the phrase allegedly infringing products, which was not sufficient to find that the act constituted fabrication and dissemination of false facts, and that Allen's claim was not established. There is a common point between them is that the patentees both send warning letters to distributors of the alleged infringer, which directly caused the alleged infringer to file lawsuits against them. And here is the comparison. Honda's warning letters only recorded the name of the patent right in question, the name of the allegedly infringing product, and the nature of the alleged infringement, without providing the customer to whom the letter was sent the specific reasons for similarity of the design or making the necessary infringement comparison. This made it difficult for the distributor to objectively determine whether to continue selling the product. Furthermore, The two companies had similar customer bases, leading the court to suspect that Honor was using the warning letter to compete with its rivals and gain business opportunities. And it's a comparison of Adam versus Mandarin case. In contrast, the court held that the warning letter sent by Mandarin to some of Adam's distributors was accurate in determining the fact of patent infringement. The Supreme People's Court of China ruled that the patentees can exercise their right even if they do so at a critical stage of a company's initial public offering. In conclusion, the court will consider the specific content of the warning letter and the clarity of the infringement to determine whether the letter was used to suppress the competitor or to protect patentees' legitimate right. So, what can we learn from these cases? First is different recipients of warning require different levels of due diligence on the part of the patentee. The duty of care of the patentee who sends infringement warnings to manufacturer counterparties is higher than sending them to manufacturers. The manufacturer, as a source of infringement, is usually the direct target of infringement warnings from the patentee. They are better able to assess whether their products are infringing and more aware of defending them. Consequently, they are unlikely to immediately seize the infringement upon recipient of a warning letter. However, as to manufacturer counterparties such as distributors and users, the duty of care of the patentee arising from alleging infringement is higher. This is because such parties are more risk-averse and susceptible to infringement warnings and may choose to remove or return the products in question immediately. So a warning letter is sent to the manufacturer counterparties like distributors or users. You should have a higher due diligence and be more careful. Now let's turn into the case study introduced next. It's a successful example done by our law firm where we achieve good results by sending warning letters. This is one of our clients' patent, and it's an English clothing company that owns a design and a utility model patent for particular clothing items. This patent was infringed by several sellers on different websites who were selling knockoff versions of the design without permission. It contacted our Gaowo law firm and commissioned lawyers to send patent infringement warning letters to the infringing sellers, demanding they stop selling the infringing products. They also commissioned our lawyers to submit formal infringement takedown requests to the platforms as authorized agents. During the commission, under the professional advice of our lawyers, we preserved evidence for the client, conducted web page notarization and evidence preservation, and applied for a patent evaluation report from China Intellectual Property Association for the client's design patent. The patent evaluation report is a report we mentioned before. And fortunately, the final report we obtained was positive, further strengthening the client's design patent's rights. Ultimately, through the tireless efforts of our lawyers, we successfully got dozens of infringers to stop infringing. The infringing products were taken down with the assistance of the platforms or removed voluntarily by the infringing sellers. Several infringing sellers also sent response letters to our law firm stating that they would stop the infringement and express their apologies and intent to cooperate with our client. Through resolutely protecting its intellectual property rights, the UK company curbed the flood of the infringing products online and protected its sales and market position in China. Okay, here is a summary. When sending infringement warning letters to distributors, the information should be more accurate. This means you should disclose the scope of the rights sought to be protected, specific details of the alleged infringement, and other information which is necessary to identify or stop infringement. This is the showing to be accurate. Or else, it may cause the distributors or sellers to become suspicious and scared, leading them to terminate the transaction with manufacturers to avoid potential legal consequences. Finally, it's come to last part, suggestion. Above all, when writing and sending a warning letter, the following points should be noted. First, the content of the letter should be specific, not vague or general. The fact of infringement set forth in the warning letter should be as transparent as possible and disclose sufficient information about the alleged infringement. The patent owner should clearly state the patent number, the identity of the patentee, the scope of protected rights, the specific product name, model number, and the patent name of the alleged infringement. Second, If the warning letter is sent to manufacturer counterparty like distributor sellers, the information of the warning should be more appropriate, such as disclosing the preliminary infringement comparison. Of course, it should be noted that disclosing all the information on the infringement facts already in the patentee's possession is unnecessary. This is because it may have back effect for future lawsuits. So it should be noted that disclosing all information is unnecessary to avoid adverse effects on the lawsuits that may be filed in the future. And it is sufficient to disclose to the recipient the information necessary for the patentee to determine whether the wrong conduct constitutes a suspected infringement in order to meet the duty of care required by law. All may face the legal risks I have mentioned above. The third, exercise the duty of prudence required and carefully consider the content, scope, and method of sending. For example, whether the infringing products falls within the range of protection of the claim should be thoroughly investigated and proved. The fourth, to avoid appearing overly broad, the warning letter should not be widely distributed. That means don't do like the Hondas to distribute its warning letters, and like is to send 23 warning letters to the sellers of Shuanghuang. The behavior is not support. And when targeting a manufacturer counterparty, warning letter should be sent with particular care. The reason we have explained before. And then, for best results, the warning letter should be written in Chinese, as it is difficult to prove the alleged infringer knowledge of the letter's contents if it is not in Chinese. And if a lawyer is appointed to send the warning letter on behalf of the patentee, they should be provided with a power of attorney signed by the patentee. The patentee should respond positively to any responses to the warning letters to demonstrate a willingness to communicate and negotiate in good faith to settle the dispute. And in closing, I hope I have given you a good overview of infringement warning letters, why they are used, how they draft, and how they can help. With the right evidence and legal backing, these letters can be an effective first step to stopping infringement and asserting your intellectual property rights. And that's all. I sincerely appreciate your attention today. I hope this information help you in your future work. Now it's your turn, Kan.
All right, dear colleagues, I think Ms. Adela has finished today's webinar today, safe and sound. Hi, Adela. I thank you so much for the complete preparation and the decent demonstration for today. It's such an excellent job for you done for the clients who showed up today. Well, ladies and gentlemen, we also highly appreciate that you took time to join us. We hope that this seminar will be contributing to your further understanding of CN pattern practice. And the Gaowo team is always standing by for any possible assistance for you here in China. And this meeting has been recorded. If you need any information, please feel free to contact. And don't hesitate to contact your key person in our firm. We are more than joyful to offer our help and legal advices on any issues. Thank you for your time and attention again, and thank you for listening. We will see you next time. Bye-bye.
Thank you. Thank you very much. Yeah.